Welcome to Deep Dive. Today, we are diving into something really significant for a lot of highly skilled workers and their families here in the United States. We're looking at the U.S. Supreme Court's recent action, or maybe inaction, you could say, on the H-4 work authorization rule. Now, for you listening, whether this directly impacts your family through an H-4 visa, or maybe you're involved in talent management relying on global professionals, well, this decision brings some much-needed clarity. This policy has been kind of hanging in legal limbo for years now. Our mission today is simple. Give you the full picture. Where did this rule come from? What was the legal fight against it all about? And crucially, what does it actually mean now that the Supreme Court has decided not to step in? What does it mean for thousands of working families? So to start us off, let's get the basics down. What exactly is this H-4 rule we're talking about?
Right. Well, this deep dive really gets into that tension between family stability for immigrants and how we interpret the laws. You know, the H-4 work authorization program, it wasn't always around. It actually started back in 2015. It came about through a specific regulation created by the Department of Homeland Security, DHS, under the Obama administration.
Okay, 2015. And what does it do?
Essentially, it allows certain H-4 visa holders to apply for what's called an employment authorization document, or an EAD. And these H-4 visa holders, they're specifically the spouses of H-1B workers.
All right. The H-1B, those are the visas for specialized high-skilled jobs.
Exactly. And there's a key condition here. This eligibility isn't for all H-4 spouses. It's tied to the H-1B spouse being pretty far along in the process of getting permanent residency. Basically, they're already approved for their green card, but stuck in those huge backlogs, which, as you know, can easily mean waiting a decade, sometimes even more.
That context is so important. It wasn't just a free-for-all work permit. It was specifically trying to solve that problem of the massive green card wait times. So if you have an H-1B worker, maybe in tech or science, their spouse, who might also be a professional, doesn't have to sit out of the workforce for 10 years. They can work legally, contribute.
That's precisely the idea. It was designed really as a policy tool to help the U.S. keep high-skilled talent. Think about it, if you're a highly skilled professional deciding where to work globally, and you know your spouse won't be able to work for maybe a decade or more in the U.S. while you wait for a green card. Well, you might just choose another country, right? Somewhere more welcoming to dual career couples.
Makes sense. So the EAD provides that stability.
It signals greater stability, yes. And the impact, when you look at the numbers, it's really quite significant. Since the program began in 2015, official figures show over 258,000 H-4 dependents have received work authorization.
Wow, over 250,000.
Yeah, and just in the last fiscal year alone, it was over 25,000.
Okay, let's unpack this. 258,000 people, that's a huge number of families, often dual-income households, relying on this. But as you mentioned, this program has faced constant legal threats, basically from the start. So who was trying to get rid of it, and what was their main argument?
The main group challenging the rule in court was an organization called Save Jobs USA. And they were very persistent over the years. Their core argument wasn't really about, the idea of immigration policy itself. It was much more technical. It focused on administrative law, basically, whether DHS even had the legal right to create this rule in the first place.
Yeah.
They put forward a pretty strong claim that the H-4 work rule didn't have a clear basis in the immigration laws written by Congress. Their contention was that DHS had gone beyond its statutory authority.
Okay, statutory authority.
Yeah.
It sounds like legal jargon, but it seems crucial here. Let's unpack that a bit. What does it mean for an agency like DHS to exceed its authority?
It's really fundamental to how U.S. government works. Agencies like DHS, they're part of the executive branch. They only have the powers that Congress gives them through laws, through statutes. Save Jobs USA basically said, look, Congress created the H-1B visa and they created the H-4 visa for dependents, but they argued Congress never explicitly told DHS it could give those H-4 spouses permission to work.
I see.
So in their view, when DHS created this EAD program, it wasn't just interpreting the law, it was essentially making new policy. And policymaking, constitutionally, that's Congress's job.
Right. That's a serious challenge, grounded in the separation of powers. But didn't they also have another argument, something about jobs?
They did, absolutely. That was the second major part of their case. It was an economic argument. They claim that letting hundreds of thousands of H-4 spouses work, many of whom are also highly skilled and educated, created unfair competition in the job market.
Unfair competition for whom?
For American workers already in those fields. Save Jobs USA argued this could drive down wages or make it harder for U.S. workers to find jobs in certain specialized sectors. They framed it as harmful to American jobs, especially because Again, the rule came from an agency decision, not a direct vote by Congress.
So it's this mix, a technical legal argument about agency power, combined with an economic argument about protecting domestic jobs. But despite these arguments, the lower courts didn't agree with them.
That's right. Over the years, as this case moved through the lower federal courts, the rulings consistently went in favor of the government, upholding the H-4 EAD rule.
Why was that?
The courts generally relied on legal principles that give government agencies like DHS a fair amount of leeway, some deference when it comes to interpreting the laws they're responsible for enforcing, especially if the law isn't perfectly clear on every detail. They essentially said that creating the H-4 EAD rule was a reasonable way for DHS to manage the immigration system, particularly concerning high-skilled workers and the long green card waits. It fell within DHS's broad regulatory powers.
So the courts saw it as a rational exercise of the power Congress had given DHS.
Pretty much. They viewed it as managing the system, not creating entirely new law without permission.
But Save Jobs USA didn't give up. They kept appealing, pushing this administrative law argument all the way to the highest court, which brings us to the recent news from the Supreme Court.
Exactly. And what the Supreme Court did was, very specific in legal terms. They issued an order declining to grant the petition for certiorari.
Certiorari. Okay, fancy legal word. What does that mean in plain English?
It just means they refused to take the case. They decided not to review the decisions made by the lower courts.
What's fascinating here is it sounds like they did nothing right. They just said no thanks. But that no thanks has huge consequences in this situation. What does it practically mean for all those H-4 spouses with EADs?
It means immediate continuity and, frankly, massive relief for a lot of people. By refusing to hear the case, the Supreme Court is essentially letting the previous rulings stand. Those lower court decisions that said the H-4 rule is legal, they remain the law of the land on this issue.
So the legal challenge is over.
This particular legal challenge, yes. The Supreme Court was the last stop for Save Jobs USA's lawsuit. By declining the case, the court implicitly validated the legality of the H-4 EAD program. It removes that huge looming threat that the entire program could be struck down by the judiciary any day now.
And we really have to stress the impact of that. The psychological relief, the financial stability. You mentioned over 250,000 people got these EDs. They've been living with this uncertainty for years.
Oh, absolutely. The anxiety was palpable in the community. Imagine planning your career, maybe starting a business, buying a home, all while knowing that your right to work could just vanish with a court decision. This ruling removes that specific judicial threat. It provides a real measure of security, telling these families that, at least from a court perspective, their ability to work is currently safe. It confirms the EAD program is, for now, a legitimate part of the immigration system.
Here's where it gets really interesting, though. Okay, so the courts have upheld the rule. The Supreme Court basically gave it a stamp of approval by not interfering. Does that mean the H-4 EAD is permanent now? Is it completely safe?
That's the crucial next question. And the answer is no, not necessarily permanent. This is the key caveat everyone needs to understand. The Supreme Court's action provides judicial security against this specific lawsuit. It confirms DHS acted within its legal authority when it created the rule.
Okay.
But it doesn't provide political security or administrative permanence. It doesn't mean the policy itself can never be changed.
So the legal argument about DHS's authority is settled for now, but the underlying policy could still be targeted.
Precisely. The critics, like Save Jobs USA and others who oppose the policy for economic or other reasons, their arguments haven't just disappeared. The policy debate continues. So there are still potential risks down the road. What are they?
What kind of risks?
Primarily two kinds. First, there's administrative risk. A future president, through their appointed head of DHS, could decide they don't like the policy. They can start the formal rulemaking process to change the regulation, maybe restrict who's eligible, add new conditions, or even try to eliminate the program entirely.
So a different administration could just undo it through regulation?
They could try, yes. It involves a whole process, public comment, and potential legal challenges again, but it's a possibility. The court ruling doesn't prevent a future administration from changing the regulation. Second, there's legislative risk. Congress could, at any time, pass a new law that specifically addresses H-4 work authorization. They could explicitly forbid it, or they could explicitly authorize it and make it more permanent.
Right. Congress could step in and settle it one way or the other.
Exactly. So the rule is currently lawful based on existing statutes and DHS's interpretation. But it's not set in stone forever. It remains vulnerable to future political or administrative changes.
If we connect this to the bigger picture, beyond the individual families affected, why is the stability of this H-4 EAD program important for, say, the U.S. economy or our ability to attract talent generally?
It's hugely important for staying competitive globally. The U.S. relies heavily on the H-1B program to bring in specialized talent, filling critical jobs in tech, science, medicine, and more. Now, if the U.S. develops a reputation as a place where the skilled worker is welcome, but their spouse is forced out of their own career for potentially a decade or more, that makes us less attractive.
Yeah, you mentioned that earlier. Other countries might look better.
Right. Countries like Canada, Australia, the UK, many have clearer, faster paths for skilled workers and their spouses to work. The H-4 EAD rule helps the U.S. compete on that front. It sends a message to global talent. Your family unit can have more stability here. It allows U.S. companies to recruit and, importantly, retain top international professionals without that constant worry that their employee's spouse might suddenly lose their job due to a policy shift.
So it's really about maintaining the U.S. edge in the global race for talent.
That's a big part of it. The economic argument for the rule is that it helps keep the U.S. as a top destination for the world's best and brightest, which ultimately benefits innovation and the economy here. Preventing a brain drain to competitor nations is key.
Okay, so this deep dive has really shown us, I think, that while the Supreme Court's decision not to hear the case is a major win for H-4 EAD holders, it provides really vital relief and confirms the rule's current legality. It's not the final chapter. The underlying policy debates and the potential for future changes, either from an administration or Congress, they're still very much alive. Which leaves us with a thought, maybe something for you to consider. If the goal really is to attract and retain the world's top talent, shouldn't something as crucial as spousal work authorization have a more solid foundation? Shouldn't it perhaps be clearly defined by Congress, rather than remaining a regulation that could potentially change with the political winds? So just to give you a short brief on what we covered. We saw how the U.S. Supreme Court effectively upheld the H-4 EAD rule by deciding not to review the legal challenge from Save Jobs USA. This confirms work authorization for potentially hundreds of thousands of H-1B spouses, bringing crucial stability. But as we discussed, the rule isn't immune to future changes through administrative action or new legislation. The regulatory risk persists. Like all the best, we hope this deep dive provided you with the clarity needed on this important matter. All the best. We will meet again with another important matter again.